All right, folks, if people can take their seats, we have students who are going to be going to class at 1, so we want to go ahead and get started in a timely fashion. My name is Greg Bowman. I have the honor of serving as the Dean here at the WVU College of Law, and I'd like to welcome everyone to this lunch event, which helps to launch our Law Review Symposium for this year on education law. And the panel today is a wonderful part of that. It's titled The Lasting Influence of Pauley and the Recht Decision on West Virginia Education Law and Policy. So again, for the students who are here, thank you. For faculty, thank you as well. And I see some outside guests as well. We're really pleased to have you here. I want to thank the members of the Law Review for making this symposium such a success. We're really excited about it. And I also want to thank my colleague Sean Tu, our Associate Dean for Faculty Research and Development, and Professor Josh Weishart, who has been one of the masterminds behind this and very hardworking. And I will turn the podium over to Josh, and he can introduce our panelists today. But again, thank you for being here. This is a really wonderful part of our programming this year at the law school, and we're very proud of it. Thank you.
All right, thank you, Greg. I appreciate all of you being here, and I'm just going to get right into it so we have plenty of time for discussion and for the Q&A. So please allow me to introduce our panelists. Mary Catherine Tuckwiller is an attorney with the West Virginia Department of Education, where she is involved in wide-ranging litigation and legislative efforts on behalf of the department and the State Board of Education. She previously practiced law at Dinsmore, but perhaps her most challenging job was not as a lawyer, but as an 8th grade English teacher in the Virginia public schools. When she's not advocating for public education, Mary Catherine and her husband own and operate a 7th generation 500-acre cow-calf farm in Greenbrier County. She is a proud alum of the WVU College of Law, and we are especially grateful to Mary Catherine, who proposed the idea for this panel and worked so hard to arrange for the other panelists to participate. So thank you, Mary Catherine. She highly recommended that Kelli Talbott be part of this discussion, and rightfully so. Kelli brings a wealth of experience as the Senior Deputy Attorney General in the West Virginia Attorney General's Office, where she has worked for over 30 years. She supervises a team of attorneys who represent state agencies and officers, and most relevant to our discussion today, she has represented the State Board and Superintendent in numerous cases, including constitutional challenges. I did not check to see if she owns a farm, but her Twitter feed suggests that she's into gardening, so that's close enough. Kelli has distinguished herself as a founding member of the chair of the Government Lawyers Committee of the State Bar. She was appointed by the West Virginia Supreme Court to draft administrative rules for administrative appeals. And last year, she was named a West Virginia Bar Foundation Fellow. Kelli is also a graduate of the WVU College of Law. Sam Petsonk did not earn his JD from the WVU College of Law, but he is still exceedingly smart and talented and has put his talents to good use for West Virginia. He spent several years as a legislative assistant to U.S. Senators Robert C. Byrd and Clark Goodwin. A graduate of the Washington and Lee University Law School, Sam won a coveted Skadden Fellowship, which gave him an opportunity at Mountain State Justice to launch the firm's Minor Safety and Health Project. And since then, Sam has joined Mountain State Justice full-time, where he practices law on a variety of public interest and class action matters. I just presume that Sam has no time for a farm or gardening, as he is actively engaged in various community and economic development projects and serves on the West Virginia Advisory Committee of the Natural Capital Investment Fund. Mary Catherine raves that Sam is the lawyer to watch in education law litigation on the plaintiff's side. I should note that Sam's colleague, Dan Hedges, represented the plaintiffs in the original Pauley litigation and has been involved in these issues for decades. Please help me again to welcome our panelists. So let me briefly set the stage for this discussion. In 1975, parents of 5 public school children in Lincoln County filed a lawsuit contending that the state school financing system violated the West Virginia Constitution. They alleged that school funding was inadequate and thus denied them a thorough and efficient system of free schools guaranteed by the state constitution. They also alleged that funding disparities violated the state constitution's equal protection guarantee. And by all accounts, Lincoln County's schools were then, quote, woefully inadequate, so much so that they were later judged to be a serious health hazard to their students. The original trial court acknowledged as much, but dismissed the case anyway. And the West Virginia Supreme Court reversed that dismissal in a landmark decision issued 40 years ago yesterday, February 20th, 1979. Before remanding that case back to the trial court, the West Virginia Supreme Court took the opportunity to interpret the state constitution and provide some guidance. And the court, first and foremost, recognized that education is a fundamental right that is entitled to the highest degree of judicial scrutiny. It also defined a thorough and efficient education as one that develops the minds, the bodies, and the social morality of children to prepare them for useful and happy occupations, for recreation and citizenship. The court went on to articulate 8 specific capacities that a thorough and efficient or adequate education should cultivate in children, from basics like literacy and math to knowledge necessary to meet the demands of citizenship, even competency in the arts and social ethics. The court said that the right to education demanded good teachers, facilities, curriculum, accountability mechanisms, and high-quality standards. Going forward, any discriminatory classification in the school funding scheme would have to withstand strict scrutiny. But the court also explained that to achieve equity in education would entail not simply equalizing per pupil spending or funding, but rather to ensure funding that met the needs, educational needs of diverse students. Quote, no matter the expenditure. Some students might require more, not equal funding. In closing, the court observed that the state constitution made public education the prime function of our state government, the funding of which was ahead of every other state function. The West Virginia Supreme Court then remanded the case and appointed Judge Arthur Reck to give further content to the adequacy and equity standards and determine the constitutionality of the school funding system. And we should note that Judge Reck recently passed away after a long and distinguished career on the bench. Judge Reck heard over 40 days of testimony from more than 30 education experts in the Pauley case. He then issued a 244-page opinion declaring the school funding system unconstitutional and discriminatory. The opinion sent shockwaves throughout the state, so much so that it would simply become known as the Recht Decision. Reaction was mixed, but it was not measured. You either loved or hated the Recht Decision. Those who hated it vilified Judge Reck as a long-haired hippie. To cure the constitutional infirmities, the state agreed to develop and be bound by a master plan for public education. The trial court would retain jurisdiction to implement that plan, or to monitor the implementation of that plan. Let me stop there. I just want to poll the panelists, if you'll indulge me. For the benefit of the law students in the room, how relevant would you say Pauley and the Recht Decision are in your education practice? Highly relevant, somewhat relevant, not relevant. Which of those 3?
I don't know if this is the one, but it's highly relevant in my practice for the State Board of Education.
Would you agree?
Highly to the point it's preeminently relevant.
Okay.
It certainly is invoked incessantly at the county level, the state level, in virtually any discourse about public education, and certainly when that discourse involves litigation.
All right, and Sam, you're jumping ahead of me. My next question was, in your experience, how often would you say that Pauley or the Recht Decision is referenced by the courts, by the state board, in the legislative process, or in your own legal memoranda and pleadings? Is it frequently, occasionally, or almost never?
For me, it's frequently, and I find that I cite it in manners that perhaps aren't likely. I just filed a brief it's not on an issue of adequacy or equity funding, but it's a First Amendment case that's in the federal court in Huntington, and I actually cited that case in a memorandum that I filed. So I frequently cite it. It probably gets cited in every education brief I file, and it's something that I've had to become a student of representing the State Board of Education.
When the State Board of Education files its rules, and that tends to happen every other month, we cite to and rely on Recht as the impetus to be able to take that lead in defining the education system and in evaluating our standards, our comprehensive delivery of education, how we will provide supports. We look to Recht and what it instructs us to do.
I would echo all of that.
Okay. And one more. If you were to compare Pauley to other famous U.S. Supreme Court decisions in terms of its significance to West Virginia constitutional law, would Pauley be most comparable to Brown versus Board, Plessy versus Ferguson, or Bush v. Gore? I stacked the deck.
Oh, gosh. Wow, that's an interesting question. I would have to say probably Brown v. Board of Education.
And Barnett, but Brown v. Board.
I would agree.
Okay, I'm just driving the point home for our law students, many of whom are products of West Virginia public schools, and we hope might stay in the state and raise their children here. Now, for the benefit of non-lawyers in the room or watching on the internet, how would you just briefly describe in plain, non-legalese terms what Pauley means for West Virginia children?
Well, I think it means two things. One, it recognized that education is a fundamental constitutional right, and from that principle, so many things flow. When it's a constitutional right, that automatically attaches all kinds of what I'll call bells and whistles that the state is obligated to step in and deliver in order for that right to be enforced. It also principally stands for the funding equity issue, and that is very important, I think, because obviously there are some counties, school systems that are more disadvantaged than others with regard to tax collections and things of that nature, and so that decision requires the state to step in and make sure that there's some sort of floor in funding for the school systems in the state, and that has to, I would think, directly impact students all over the state of West Virginia.
Thank you.
I think it acknowledges the inevitable disparity geographically, economically, professionally within the state. And if you look historically, certain of our regions that are economically thriving now were economically depleted 20, 30, 50 years ago. But regardless of which region you're from, it's a commitment from the state to try to give all of our public school children a baseline where if you are learning in McDowell County and you relocate to Berkeley County, you're going to have some semblance of consistency and dedicated emphasis on those things that you're constitutionally owed.
Thank you.
I'd say it has to be explained for students, but also for their families and for their employers. Thoroughness and efficiency, adequacy and equity mean that you have, as a citizen of our state, you're going to get you're going to have a basic education in certain fundamental areas, and the means by which that education is provided to you will not vary regardless of where you live or how wealthy the folks are around you. And that's got a lot of meaning for the kids, but it also, as I think was, has to be explained every time you talk about the real personal meaning of this case. It's every bit as meaningful to the community of employers and families that surround those kids. All of those interests in efficiency and equity of opportunity are intertwined as between the interests of children and all the people that deal with those children throughout their lives.
Thank you. So Kelli, we know that after the Recht decision, for much of the 1980s, the state basically dragged its feet in terms of implementing that master plan. Voters also then rejected a statewide levy that would have replaced the local regular levies. And also during that time, we had the creation of the school building authority that helped pay for the construction of dozens of new schools and provided renovation funds for existing schools. There was also some meaningful reforms instituted after the first statewide teacher strike in 1990, but certainly none of this came close to the full implementation of the Recht decision or the master plan. So tell us what was happening in the courts, particularly in the mid to late 1990s. Can you walk us through some of the more significant developments in the case law?
Yeah, I mean, I will say that as a preface, there was one case that was decided in the late 80s. It would have been before my time in the Attorney General's office that I think is quite significant, and it's the Heckler case. We call it the Heckler case. It's the case in which the State Board of Ed kind of flexed its muscles and was very bold and decided that it wanted to kind of set up a test case, so to speak, that went to our Supreme Court about the scope of their authority to promulgate policy and rules. And in that case, the Heckler, being the Secretary of State at the time, wouldn't allow the State Board of Ed to file a rule with the Secretary of State, which is typically the repository for rules to be filed in. And because it was the Secretary of State's position that the State Board of Ed didn't have the authority to promulgate policy or rules without legislative oversight and ultimate approval. And that case ultimately came down from our Supreme Court saying that no, the State Board of Ed had the constitutional authority to promulgate rules, to promulgate policy, education policy, and that it did not require legislative approval for that to happen. And that case is significant. I cite that case a lot in my practice for the State Board of Ed. But that is kind of a landmark case in my mind that really defines how the State Board of Ed operates, because as many of you may know, generally in state government, state agencies do have to get legislative approval for their rules. The difference being with the State Board of Ed, given their constitutional status and their ability to, under the Constitution, to generally supervise public education, they don't have to have legislative approval. So that case was significant. But then into the 90s, during the time that I was in the Attorney General's office, the legislature, of course, passed a statute, we call it 182E5, which is a significant event because that was what triggered Judge Recht dismissing the case. And that statutory framework set up an accountability mechanism by which the State Board of Ed could review the performance of school systems and could ultimately intervene and take over, so to speak, a school system that was failing to meet the appropriate measures. So the State Board of Ed during the 90s exercised that authority and took over several school systems, and those takeovers or interventions resulted in litigation. And there was a case that arose out of Lincoln County when the State Board of Ed took over that county school system. Some of the citizens sued to contest that. There was a case that arose out of Mingo County when the State Board of Ed took over that school system for the second time. And also there was another case that arose out of, and the county's escaping me, I believe it was a southern county. And so we litigated those cases. They were all in the Circuit Court of Kanawha County, which at that time, and until recently, the state board could only be sued in Kanawha County under state law. That's recently changed, however. But we were in front of various judges in Kanawha County in which we were looking at the scope of the state boards of authority. Could they take over a school system? Could they decide to close and consolidate schools? Because that was largely the issue that citizens were complaining about in those cases, was the state board's decision to close and consolidate schools. And all of those were decided in favor of the State Board of Ed with a very expansive view of their authority, which I believe flows directly from the Recht decision. And interestingly enough, at the time, 2 of those cases were appealed to the Supreme Court, but it was during the time when our Supreme Court had the authority to refuse to hear lower court decisions. So in those particular cases, the Supreme Court did not hear those cases, and we don't have any reported case law other than obviously the circuit court orders in those cases. But in the case that came out of Lincoln County, if you look at the order that I believe it was Judge King in Kanawha County Circuit Court entered, he cited quite freely from Rec's 200 and some page or 300 and some page order, basically saying that the State Board of Ed was fulfilling its responsibility directly under the Recht decision to do what it did in Lincoln County. So we had those cases in the 90s that kind of dealt with that intervention and what the State Board does in those circumstances, what it can and can't do. And those were, I had the privilege of representing the State Board of Ed in those cases, and they were quite interesting. So I don't know if that's, but that's basically, what I think that all of those cases flowed out of the Recht case. I know that 182E5 has since been amended, and we'll probably talk about that,
Yes.
but that's what happened at that particular time.
So just to go back to something you said, because I want to make sure that everyone understands what happened with the Pauley case. It changed names, but it was effectively the Pauley case. And remember I said Judge Recht continued to have jurisdiction, or the trial court had jurisdiction to monitor it. And you said that Judge Recht, he found that 182E5 state statute was a legislative educational epiphany, I think he said. And that it would set in place the mechanism for implementing the master plan. So then why did Judge Recht, do you think, decided to terminate jurisdiction? The state had not complied with the Recht decision at that point for almost 20 years. And yet Judge Recht was inclined to terminate his jurisdiction at that point.
Well, as I recall from what his order said at the time, it was that he felt like the framework that 182E provided would be not only to look at inputs like how much money is spent on education, but the outcomes, and that this review process and the audits and things that the State Board of Ed would do would be focusing on outcomes. And it may or may not be a funding issue to affect outcomes. It could be, but it may not be. So he felt like that needed a chance to work. And I'm sure, I wasn't around when that order was entered. Maybe he was a bit tired of hanging on to that case. I don't know, after all that time. But I think he wanted to give the legislative and executive branches a chance to see if that accountability system would work, and that's why he let it go. That's the way I see it.
Yeah,
anyway.
he did say he gave him a chance, but he
Yeah.
didn't say that the court would never be back and intervene.
Right.
Let's bring Mary Catherine into the discussion, because she deals with 182E5 quite a bit in her capacity. What's the significance of that law?
Sure. 182E5, as Kelli said, is the portion of the education code where the legislature spelled out essentially the process for improving education and said there are 4 elements: standards, assessments, accountability, and continuous improvement and capacity building. And one of the things that is interesting, and I would like to acknowledge that 2 of our state board members are here today, Jim Wilson and Scott Rotruck, and what a phenomenal responsibility they have in affecting the statute, but the legislature affords the state board the opportunity to define the rules and policies to accomplish these things. It calls for our students to have a statewide assessment program, to have some measure of how they are achieving. That is what has been so controversial with which test will we give, what grades will we administer the test, will it be a uniform test across the state or something that is nationally normed but different so that we can see what our counties are learning, talking about annual performance measures, talking about standards that include, as we've emphasized, finance, special education, facilities, how our students are performing, digital literacy, a number of factors to show that it is not isolated to any single measure. And recently, we've come out with something called the balanced scorecard. Historically, we had something called the A to F system where we gave schools letter grades to indicate how they were performing. The balanced scorecard is a broader look at what our schools are doing and how they are achieving, how our counties are achieving, to allow us a better view at that equity, at that thorough and efficient delivery. I know Sam is going to be familiar with that as well as it pertains to buildings. But this is what we turn to talk about how our schools are doing, and it was amended significantly in 2017.
How so?
A couple of different ways. The legislature has engaged in a conversation back and forth with the state board for a number of years regarding what the actual constitutional responsibility of each entity is. The legislature provides for a thorough and efficient education by general law, and then the State Board of Education defines what that is. And in the TUG, the legislature added some language saying that they have the authority to be engaged constructively. They reinserted themselves into the process to have a greater hand. It also changed the method by which the state board can intervene into school systems to give the local school systems a greater opportunity to improve on their own, as opposed to immediately jumping in and removing local control.
Yeah, Kelly alluded earlier to a tension between the legislature and state board in terms of the division of powers, responsibilities, and perhaps not surprising, a former English teacher thinks that tension could be resolved through a grammar lesson.
I'm sure that everyone will be really glad to indulge me, but I have been fascinated by the grammar of the Constitution and the fact that Article 12, Section 1 says that the legislature shall provide by general law for a thorough and efficient system of free schools, not that the legislature shall provide a thorough and efficient system. And so I've dwelled in on that phrasal verb and taken that to potentially mean that they are going to supply the means to give this, but not actually deliver it, because it is the educational experts. Now, I've not taken this to task in litigation with anyone, but this is something that I've seen, whereas then you go to Article 12, Section 2, and it says the general supervision of the free schools of the state shall be vested in the West Virginia Board of Education. And so it's very unique compared to a lot of other states that have a more localized delivery of education. I think that that is pretty clear constitutionally.
Sam, I want to get you in just a minute, but I want to go back to something Kelly and Mary Catherine both mentioned, which is, and I think something that has sort of slipped under the radar. In the original Recht decision, he was critical of the school funding formula being resource-based, meaning that it is driven primarily by the costs associated with enrollment. He effectively says, and I think consistently with Pauley, that equal per pupil funding across the counties, that's not the measure of equity. That's not what the Constitution demands. Judge Recht advocated a needs-based funding formula. And then by the late 1990s and the early 2000s, the parties and Judge Recht become enamored with the adequacy theory, and based upon the outcomes and the performance model, and that's implicated in this statute. So they become focused on the outcomes, the test scores, the graduation rates, but it seems to me you cannot expect students to achieve certain educational outcomes unless you meet their educational needs. And so don't you think that the funding formula needs to be both needs-based and performance-based? Anyone?
needs, costs, were all the factors I think that Judge Recht wanted to voice with a view towards equity in both opportunity and results. Is that a fair summary of the principal metrics that he
I think he
invoked?
became really focused on the outcomes, right? And he saw the statute as embodying a mechanism for holding educators and the state accountable for achieving those outcomes. But I think we missed part of the other part of it, which is a link back to the needs equity that he was so focused on in the original Recht decision.
Yeah, I'm not really sure that the funding formula has changed
It has not.
significantly even since that amendment to 182E5. I mean, it's still primarily driven by enrollment, is it not? I mean, I'm not a funding formula expert, but I think that's true. Can y'all hear me? I'm sorry, I wasn't close enough. I just basically said that I didn't think the funding formula had changed significantly over the years. It's still primarily driven by enrollment. So perhaps that's an area that's ripe for litigation.
Or just some evaluation.
Yeah.
It's not been evaluated since it was developed in the 1960s. Now let's so we're up to the present day now. So Sam.
May I just?
Oh yeah, please, I'm sorry. Yeah.
And I don't want to preempt if you're going
No,
to get
no,
to
no.
these questions, but as you're looking at I think that the legislature is looking at that question, so it may not have changed substantially. And there are certainly folks in this state who make a career out of understanding the school aid formula. I'm not one of them, but I do think that but we do follow the activities in the legislature, and they are looking at this issue. And Judge Recht's focus wisely on addressing the role of levies and bonds as a mechanism that was of concern to him, I think is a policy concern that we need to bear in mind as we evaluate what the legislature is contemplating right now when it comes to the formula funding and also facilities funding.
So Sam, just stick with you. What do you think are the most troubling educational deprivations and disparities? We have them, of course. Every state does. But what are the most troubling ones to you? From the perspective of, the plaintiffs that you represent.
Well, there are a lot of locally troubling outcomes when it comes to consolidating schools. I don't think you resolve all of those through a constitutional discussion or a constitutional framework or through litigation, although people often try to resolve those disputes through litigation. But the most concerning thing to me, I think, I guess the most concerning thing to our constitutional framework about education may be when we see counties within our state, or more troublingly, pockets within certain counties within our state that are unable to show educational attainment or educational advancement, or are unable to maintain the facilities that are necessary for that advancement and attainment. And when we see that those counties or those areas within counties are deprived of the resources to accomplish that advancement for reasons that relate to the inability of the county locally to generate or derive income to accomplish that advancement. I think if that's clear enough, I hope that's a summary of what we see going on. And I think that there's a policy conversation happening in our state right now about whether the responsibility for addressing that delta or funding the deficiencies will devolve to the local level by means of increased excess levies or more substantial bonding practice. And when you look at some of the least economically well-to-do counties in our state, and you think about, are we going to obligate those counties to fund this basic service through issuance of bonds? What about that? doesn't ring alarm bells from an efficiency standpoint long-term. When those bonds don't work out, this state is going to have to unwind that situation. And so I think that's I see that happening in different areas around the state. It's when the progress is held back because of this funding dynamic that takes that devolves to the local level. I think it's a very from a policy standpoint and from a constitutionality standpoint. There are a lot of alarm bells that I see there.
So you mentioned the policy discussion debate that's currently happening. I know you're not supposed to speak ill of the dead, but now that SB 451 has been defeated, it's no secret that I was not a big fan. We're likely to see the charter and voucher provisions again, either in this session or next. Which proposals in the now defunct SB 451 or other proposed legislation that is working its way, do you think would progress our compliance with Pauley and the Recht Decision? Or which ones do you think would set us back?
Gosh, that's something I hadn't given a whole lot of thought to. I guess that to the extent that the bill would continue to elevate the teachers' salaries, I think that's a good thing, because you want to have, you want to be able to attract qualified staff, and paying them is part of that. So I definitely think that was a good thing. As far as what was concerning about it, well, I know an initial version of the bill actually had an increase in class size, which I thought was interesting, because all of the literature that I've read is representing the State Board of Ed and having to learn these issues is that typically a smaller class size will advantage students. So that was particularly concerning, and I'm not really sure what was driving that. I know that it came out of the bill eventually, which was a good thing, but that was definitely concerning when I saw that.
There was a provision in 451 that is also running as a separate bill that involves open enrollment, and I think that could be beneficial. Excuse me. Thank you. And the reason that could be beneficial ties in with what Sam is saying. And one of my jobs is to handle appeals of denials by counties to accept students into their counties when they would like to attend. Often a school is 2 miles from a child's home, but is in a county other than where the child resides, placing them on a 45-minute or an hour-long bus ride. And I think when there is some degree of flexibility so that you can attend a proximate school instead of a school that is simply within the area that you live, that can have great benefit. There was some discussion that it was athletically motivated, but it was not. It was truly to acknowledge that there are often opportunities for children that are more geographically available. Dr. Wilson is smiling. There may be some athletic benefit to it. The SSAC brings that part up. Yes, but that is one aspect of the bill that I think could be meaningful, and they did look at the ways that funding would follow the student so that the inequity between the county losing money and the county inheriting the student would be able to meaningfully educate that child.
Are you asking for the high points of
You don't- and
451,
you don't
or
have to
you just
confront-
want to dwell on the low points?
Well, you don't have to confine your answer to the SB 451 either. You could discuss other proposed legislation.
Well, I guess I would, like Mary Catherine said, that let's look at what's actually moving now. I mean, if we're looking at bills in the legislature that have attempted to repeal the comprehensive educational facilities planning framework. Now, I don't know that there's any policy justification that's even been, that to my knowledge, that's set forward for public discourse as to what justifies that policy proposal. But I certainly would question it if it came forward as to how that such a policy justification is consistent with any of our law or our constitutional law. our statutory or constitutional law. And then I also really worry about, and I think that it's important for our, as a way of stewarding the Pauley framework, we have to discuss whether we believe it's workable for counties to be called upon by the state legislature to fund their needs and costs by expanding excess levies and issuing bonds and relying on bond revenue, because there are several mechanisms in bills that are moving in the legislature right now that would really obligate counties to go that direction. That would certainly authorize counties and enable the legislature to pressure counties to expand those sources of, and really to rely on those sources of revenue to meet fundamental needs and costs of maintaining facilities. And we have a massive shortfall as to those needs. The board is trying valiantly to recommend to the legislature for the funding of maintenance, supplies, vocational education, mental health, and alternative discipline. The board's done, I think, an incredible job of outlining the pressing needs for school funding, and when the legislature attempts to tell the counties that the way they'll fund those needs is by increasing their levy, I think we should have a conversation with our local county boards as to whether that's possible, regardless of the size of your county. Every county, regardless of the property wealth of that county, should have a conversation about how possible that is, politically, economically, any way you slice it. So I just think that those provisions are really worrisome. And if as a policy matter, the legislature continues to go in that direction, I think it's going to put the board in a very difficult position, and it's going to put our schools in a very difficult position to sustain these basic services. Something
else that's worrisome to me, at least, and again, not to go back to SB 451, but in defense of that bill, we had a Judiciary Committee chairman read from the dissent in Pauley. We also had the House Judiciary Committee chairman openly question on the floor debate whether the Recht decision was still good law. So I guess my question is, reading the tea leaves here, are we worried that there might be a challenge that would attempt to roll back Pauley?
I heard those comments as well, and it was concerning to me, not only as a lawyer, but as a citizen of the state. I am concerned about that. And of course, being a lawyer, I kind of want to get down into the details. I want to know exactly what it is they want overturned. You know what I'm saying? Yes. I mean, because the devil is always in the details, and I don't see, obviously the Pauley decision stands for the fundamental right under our Constitution to an education. I don't see how you overturn that principle, but, stranger things have happened. So, and then we get to the equitable funding issue. Perhaps that's what some are thinking needs revisited. But again, obviously we have disparities in our state as to ability to raise revenue to run our schools. So are we headed for a situation where there is no funding equity requirement, and literally I can see some school systems having to shut down? I mean, I don't know how they would operate in places like McDowell or some of the more disadvantaged counties absent some sort of state funding. So I'm concerned that there might be, and I, to be honest with you, I think that had the bill passed, there might have been litigation, and perhaps there are some that were counting on that happening, right? So that they could get it back in front of our state Supreme Court and revisiting some of that decision. And it's, I certainly value education. I was a graduate of the public schools in this state, and I would hate to see our state go backwards, and I fear that perhaps we could be headed that way.
had, prior to 451, long anticipated a suit in the opposite direction involving adequacy. I think that we focused on equity for so long, and folks like Sam would have a very good reason to bring an adequacy claim. And now I see it taking a 180-degree turn, and certainly was taken aback because of the fundamental need for public education for children, regardless of what state you were in, but in particular for West Virginia. I was not a West Virginian by birth, but it has been my home since I started here at the law school, and it's very important to me that we continue to provide a meaningful public education to our children. And so, like Kelli, I don't know what angle they would take, because to me, the angle that needs to be taken is a review of adequacy.
Well, if we go back to the Pauley dissent, the easiest way to roll this back and not to give ammunition to the opposition is to simply say that it was a political question, that the court should never have gotten involved in the first place. And in fact, this is what South Carolina just recently did. So after litigation for many years in South Carolina, you had a switch of justices, you had change in the justice court composition at the Supreme Court, and the court said we were in error to get involved, and we're taking ourselves out. So that's the easiest way. Let me open it up to questions, not to end on that note, but let me open questions from the audience. Professor?
Thank you all for being here. It's often seemed to me that when Judge Gregg got out and said we moved from an inputs to an outputs model, we're going to look at accountability, that some of the things he said, at least in jurisdiction, seemed to suggest the notion was once we have this accountability system, we'll be able to have hard data about where schools are succeeding in educating students and where there's not, and that will tell us how to target resources. So it's always seemed to me that he thought that accountability would lead to what some people call vertical equity model, or resources being targeted to need, and would make sure that we didn't just have, as Mary Catherine put it, equal resources, but we also had adequacy. And my sense is that was a hope of his, that almost nothing has been done to push in that direction. But you all are closer to the gears and the levers of state power here than I am, and I'm wondering your reaction in any.
Can you comment about the takeover process and outcomes?
I mean, I guess Mary Catherine might be better able to answer that than I am, because I always say they just call me when they get sued, you know. That's kind of what I do for the Department of Ed. But I don't know, Mary Catherine, has there been more focus on, I mean, obviously the State Board of Ed itself doesn't have the ability to appropriate funds. They have to rely on the legislature to do that. They can be an advocate, I guess, for funding, which they are, and they have been. Recently, I know they had their finance committee make recommendations, but I'm not sure there's been any major movement by the legislature to really, at this point, maybe the discussion's starting, as Sam suggests, to kind of change that whole paradigm of how school funding is done, whether they really look and say, hey, this particular need is in this county, we need to give them more money for this. I'm not sure that that's really happened.
I think that the information is there. I'm not sure it is being utilized in the way that it was intended by all of the necessary parties. I think that the State Board and the department are doing an exceptional job of trying to put that information out there as a useful resource, whether it be to the counties and the parents to say, here is where your children are achieving, here is where there are academic deficiencies, your math scores need to improve, something as baseline as that, or something more substantive, as Sam pointed out, our pockets of disparity even within a county, but there is only so much that can be done. And I know we worked together on a case, I like to use the word together even though we were on opposite sides. We worked together on a case where a subset of Fayette County was looking at an inequity and how that might be handled.
Yeah, your question is, have we made headway on adequacy, on measurement, I guess. And I think that my understanding is that the OEPA perhaps made too much headway for its own sake, and now it's gone. So we made headway as a result of these cases, but now I think we're continuing to make headway in part because in abolishing the OEPA, the legislature didn't really fundamentally remove the measurement obligations that OEPA held. So the board continues to carry, or the department, I guess in tandem, continue to carry those measurement obligations, and the question about how consistently they address the deficiencies that they identify through that measurement process is opinions really differ on that. And so I mean I don't know the best answer is the statutory framework is still there to do the measurement. The legislature may not be adequately funding the attainment of that measurement, and that's a real concern. And furthermore, when the measurement is done, like it was done in Fayette County was declared a deficient county, it was put into the capacity statute, put through a process that would be intended to improve the outcomes, and then the county was stuck, having been measured and evaluated as underperforming. The county was stuck in neutral because, for a variety of reasons relating to these debates about school funding and the SBA and a lot of policy prerogatives that get brought to bear, the county was unable to advance in its progress on those metrics, was unable to raise the funds, was unable to do a lot of things that were necessary. And that's really largely what led to the Fayette County litigation, is that the measurement had happened, the county had been put through put into a remedial process, but hadn't emerged from the remedial process. So I think there are, we still have the metric in statute and all the applicable metrics, I think, and really the question is, how consistently is the state enforcing those metrics when they are found to come up short? And that's a question for the legislature to probably conduct some better oversight about.
We have time for one more. I know the students have 1 o'clock class, so one more question? Yes.
Thank you all for being here. I had a question. Professor Weishart had alerted me last semester to something that I was familiar with, but he refreshed me on, which was the textbook war that had taken place in Kanawha County. And there's a recent trend in the legislature. I know that they passed legislation relating to local counties having control over the textbook selection and adoption. And thinking about that in the context of Pauley, thinking maybe it would fall in line with adequacy or standards. Do you see or foresee that if the county boards have the control over selection textbooks, pending a possible litigation over questions of adequacy of what they select in their document?
If they're here listening today, they might like your idea. One of my other lucky roles is to review all of the textbook contracts for the state. And so I'm very familiar with what they have. And the way that that changed is to say that 80% must meet the standard that the state defines. So we still have a multiple list that we put out in every subject periodically that they can look to, but then they can supplement that at the local level. Curriculum decisions are made locally, whereas standards are driven at the state level. And we spend a lot of time educating on the difference between standards and curriculum because it's easy to intersperse those two words. I could absolutely see some sort of adequacy challenge, particularly if you have materials selected that go to extremes in one direction or the other. I know that Texas recently had issues with whether Helen Keller was going to be removed from textbooks. So certainly, if there is a segment of the population that is particularly beholden to one philosophical idea or another and finds it to be inadequately represented, that would be an ideal opportunity to suggest there must be a better way. I don't know if you'd see two counties going at it, but I think you might see a school board versus parents.
Well, thank you so much, panelists, and thank you all for attending. The conversation continues tomorrow morning, and throughout the day tomorrow. We're going to continue this symposium, but please thank our panelists for helping us. And they're here if you want to remain and ask them questions personally. Thank you.